as Corey indicated, this is a two-part, and I'm mostly going to talk about conventional administrative law today. And then when we come back, we'll talk about administrative law being stood on its head, which is what's been happening for the last 2 months, and some of the laws and issues there. So this will probably, good chunks of this somewhat remind you of your ad law course in law school, or more conventional ad law that you've done. What we do in 2 weeks will not look like that at all. But we're obviously concerned with things that the administration is doing, may do, plans to do, that have adverse effects on our clients, and what ad law can do to help with that. Broadly speaking, there are two choices they face: whether they're going to promulgate rules or issue guidance, and whether they're going to exercise discretion and interpret law. And that effectively gets you a 2x2 matrix. And I want to talk about their choices, or the limits on their choices in each of those settings, starting out procedurally. Procedurally, they have a choice between issuing rules and taking an informal action, guidance, policy memos, executive orders, whatever you want to call it. The rules are quite different for the two of them. I want to start with to what extent they have to make policy by rule. The main authority requiring agencies across the federal government to make policy by rule is Section 553 of the Administrative Procedure Act. It has some exceptions in it, and there are three exceptions, or sets of exceptions, that I think we need to talk about at the beginning, and then one that I'll discuss much more rapidly. One is there is an exception that I'm guessing until recently no one on this call gave any serious thought to, for a military or foreign affairs function of the United States. No, they don't have to make rules to decide which islands they're going to build military bases on in the Pacific or whatever. I don't think anyone would ever contest that, or on this call would particularly care. But the Department of State on March 14th issued a remarkable notice in the Federal Register saying effectively that everything involving immigrants is a foreign affairs function of the U.S., and therefore they don't have to make rules on that. That would be getting not just the Department of State, but the Department of Homeland Security, the Department of Justice, or any other part of the federal government out of complying with notice and comment rulemaking to the extent that they're affecting immigrants. That's a big problem. And fortunately, it's not supported by the law. The Attorney General was deeply involved in passing the Administrative Procedure Act in 1946 after a very long process, and wrote a manual that is sort of the official original interpretation of it. And he says that it should not be loosely interpreted to meaning any function extending beyond our borders, but only affairs that affect relations with other governments. In other words, Secretary Rubio is completely out of bounds with this action. And the courts have reached a similar view. In the Ninth and 11th Circuits, the interpretation has been that this only applies to rules where the administration is trying to avoid an undesirable international consequence. That's not domestic immigration law. And in the other circuits, it says that it has to clearly and directly involve foreign policy. The Ninth Circuit said serious questions might arise if the immigration authorities engaged in foreign policy matters outside the scope of usual functions with disregard to the APA and due process. Well, that's exactly what Secretary Rubio is suggesting here. And there have been courts on related issues that have intervened. The Second Circuit said that domestic enforcement measures are not foreign affairs functions and are not exempt from rulemaking under Section 553. And the first Trump administration was told that an asylum ban cannot be imposed without rulemaking under the foreign affairs exception. So they're out of bounds there. There's also an exception that applies under Section 553A2, saying that this requirement of rulemaking does not apply to the extent that there is involved a matter relating to agency management of personnel or to public property loans, grants, benefits, and contracts. That's very murky language. The Attorney General's manual, again, says that that applies only to the proprietary functions of the government. So in other words, they don't have to make rules when they change the federal employee health plan or federal employee pension arrangements or what have you. Veterans are obviously former federal employees, so that might be covered as well. When they wrote the act in 1946, there was not anything like the complex programs we have today. There was no SNAP, Medicaid, no Medicare. There was Social Security, but it didn't cover people with disabilities. There was the predecessor to TANF, which was called Aid to Dependent Children, but it was basically a block grant to states. Some would say slush fund for states. So there's really no reason to think that Congress had in mind the programs that we're dealing with today when they wrote this, and the Attorney General says it's proprietary functions. Agency management personnel, that's obviously proprietary, and read in that context, public property, again, pretty obviously proprietary function. Loans, grants, benefits, and contracts is a little less clear, but it still is effectively readable as being part of internal agency management. Nonetheless, HHS has claimed that they don't, by notice published a few weeks ago, that they don't have to comply with the Section 553. Many agencies under President Nixon, that great champion of open government, Richard Milhous Nixon, told us that the agencies had to comply with the rulemaking functions of Section 553. And in particular, the last bullet on this slide was a notice from the Department of Health, Education, and Welfare committing to follow Section 553. As you know, the successors of that agency today are three: HHS, Social Security, and the Department of Education. Secretary Kennedy took HHS out of that waiver and therefore out of obligation to comply with the rulemaking requirement. We have not heard from any of the other agencies, and there's reason to believe that the motivation for HHS's action was fights involving the National Institutes of Health, which less directly affect the people on this call than some other things. But I think it's only a matter of time before the lawyers at HHS and at DOJ and the people in the White House start asserting that they can make policy without complying with Section 553 in other areas. I would note that there are administrative waivers for a number of other programs. Again, Social Security and Ed are still covered by the original waiver of HEW. USDA has one. HUD has one by regulation. And there are some statutes that require notice and comment rulemaking. SNAP, Medicare, tax provisions, which would include premium tax credits under the Affordable Care Act, all have independent statutory requirements that do not depend on the public grants and benefits exception. So certainly for non-HHS programs and arguably for HHS programs, these requirements still apply. There also are other things that are not full notice and comment rulemaking, but can be helpful in a number of circumstances. There's requirements of public comment on WIC and on TANF, on the tribal administration of SNAP, and on many waivers in Medicaid. And those are, again, not dependent on Section 553 and not subject to any of the exceptions. There also is longstanding administrative law saying agencies must comply with their own regulations. And there are many of these. I didn't collect all of them. There are a great many in Medicaid itself, and various other places where they're required to submit things to various people, Congress or interested parties or agencies, get comments, consult, and so on. All of those would indisputably still be effective, even if what Secretary Kennedy did stands. And then finally, there's an exception in Section 553B for interpretive rules, general statements of policy, rules of agency organization, practice, or procedure. This has been used a great deal by many, many agencies, and guidance documents, dear commissioner letters, all state letters, and whatnot. This is been defined quite narrowly by the courts, in particular for them to make policy through guidance without going through rulemaking. They cannot restrain government officials' exercises in discretion. Many of the things that we are seeing going out these days as guidance documents are absolutely constraining their discretion, and as such, those would have to be promulgated as rules. They are not guidance. It also can't affect the rights of anybody outside the government. They can divvy up rights between one government agency and another, but they can't affect you or me or our clients. And again, many of these things that are being put out as policies, not as rules, clearly affect the rights of people outside the government. This notion of shutting down telephone applications for Social Security would seem to be a pretty obvious example of something affecting people's rights outside the government. And finally, guidance may not contradict duly promulgated regulations. USDA just put out some very offensive guidance, actually a few months ago, some very offensive guidance that flatly contradicts one of their regulations. That guidance is not valid. That guidance, you cannot repeal a regulation by guidance. The exceptions for from notice and comment rulemaking, as the courts have said, are narrow ones. The purpose of notice and comment is to have broader public participation and fairness, and to help agencies not make mistakes. And those purposes are defeated if notice and comment rulemaking does not take place. So there's lots of cases. I just pulled a few of them here where the courts have cracked down on agencies trying not to go through notice and comment rulemaking. They cannot avoid rulemaking where substantive rights are at stake. They cannot foreclose other courses of action that would be available to them. They can't say, well, we have the power to do X, but we're not going to. That can only be done through rulemaking, sometimes not even there. And they can't impose a binding norm on the federal government. They can say, we will consider this, we will talk to that, but they can't say this is the principle we're doing. One binding norm after another is coming out of these agencies right now, which are not being promulgated as rules. They have to leave the agency and its decision makers free to exercise discretion. And again, that's not consistent with what they've been doing lately at all. The rules have to leave discretion where it was. They cannot circumscribe administrative choice. They've sometimes said, well, we're putting out interpretive rules, we're just interpreting our regulations. That's fine if they're deriving a proposition from a rule that is compelled logically by that existing rule. In other words, if there's a rule about vehicles, they can say, yes, trucks are covered. That's a legitimate interpretive rule. But if they say, oh, and we also think this applies to dishwashers. Well, no, that's a different policy. You can't interpret your way from vehicle to dishwasher, and that would have to be done through notice and comment rulemaking. And they, again, cannot determine the rights of procedural parties in a procedural rule. If a procedural rule says you fill out Form A instead of Form B, that's fine. But if they say you can't apply for this thing, or we won't grant this thing, or these requirements won't be, will never be waived despite our having the authority to do so, that is improper and violates the APA. And I should say, I'm clicking fairly fast here. I've already provided Corey with my slide deck, and I'm assuming that it'll be available in some form to people afterwards. So no need for hurried scribbling or screen captures or whatever here, unless something is particularly fetching. Again and again and again, I'm giving you several different cases here, but they all say about the same thing, that we narrowly construe the exception for procedural rules, statements of policy, and so on, and they cannot affect substantive private interest. In other words, if you care, it probably can't be guidance. If you don't care, maybe it can be in guidance. There. Then briefly, there is an exception for emergency rules. The agency finds good cause and includes the finding in its statement of rule that a notice and public procedure are impractical, unnecessary, or contrary to public interest. Every new administration has decided that the old administration's policies are terrible, and it is impractical, unnecessary, or contrary to the public interest to delay wiping them out. And the courts have almost unanimously said, no, the fact that you really disagree does not make it an emergency, and the fact that you're slow does not make it an emergency. Notice and comment rulemaking actually can be done quite rapidly. They could have, in theory, if they published a proposed rule on their first day in office, be getting very close to finalizing it now. Probably couldn't, because they're firing all the people who would do the work, but legally they could, and courts have been very unsympathetic with policy-driven impatience or dawdling agencies trying to cut out notice and comment rulemaking. So I'm sure we're going to see lots and lots of emergency rules from these people, but the case law on that is extremely good for us and not at all friendly for them. So what happens if they do go through notice and comment rulemaking? What does that entail? And the answer is a minefield. There's lots of mines out there, and if you have smart people doing careful work and spending a fair amount of time, you can absolutely maneuver that minefield. However, the very people I just described, oh, they've been fired. Or a lot of them have been fired, or the people who helped them do their work have been fired. So the agency's ability to make rules is very limited. And this is, I think, something that is distinct from Trump 1.0, is that they didn't make a serious effort to shrink the federal workforce. And they did a lot of heavy lifting on benefits regs, on immigration regs, on other regs, and got them through the process. I don't see how they could possibly do that now. They don't have many workers anymore in many of these agencies. They're shrinking as we speak. They're, to use the words of OMB Director Vogt, they are traumatizing these workers, which means morale and productivity is probably terrible. And frankly, a lot of the rules that made it through the process last time were the result of career people telling political people, if we do it your way, it won't work. And the political people listening to them. No one's going to say that now because people who've pointed out the constraints of law have been fired. So my guess is that rather than following this windy road, we're going to see one collision with a mine after another on this. Indeed, some of the rules that legal services advocates got struck down in Trump 1.0, the career staff, it turns out, told the administration, if you do this, you will lose in court. They got ignored. The career staff decided that they were only obliged to say it once, so they let the rule go forward with the clearly illegal stuff in it, and we picked them apart in court, and that was the end of that. I don't think anyone's even going to warn them once on a lot of these things now. So I think we should be very optimistic about our ability to attack rulemakings when we finally see them. Failing to specify what policies they want to implement got them defeated. Adding provisions in the final rule that were not in the proposed rule got them beaten. Ignoring arguments and data in public comments got them beaten. And regarding responding to arguments and data in public comments that didn't match their final rules. They say, oh, we'll absolutely monitor that and take steps accordingly, and their rules didn't allow them to change anything. So these are examples of mines that the first Trump administration, much better staffed with a much more engaged career staff, still messed up. The new one is going to do far worse than that. And many of the rules, because of all these requirements, either lost in court or they didn't get them finished. In SNAP, they had 4 really terrible proposals. They only finished 1. 3 of them timed out and got dumped when Biden came in. And the fourth one got enjoined and then dumped. So they made absolutely no rulemaking progress on their ugly agenda in SNAP because of these requirements. So this stuff is very real and can provide real benefit for our clients. There are 3 things that they're required to do under Section 553 when they make rules. First, they have to give public notice. And second, and the public notice can be criticized, in particular, if the final rules depart from the notice, the proposed rule, then we didn't have an opportunity to comment. I put in the chocolate manufacturer's case. There's a bunch like that, but I like the case. They put out proposed rules saying that they might want to restrict salt and fat and sugar in certain foods in the school lunch program. And then in the final rule, they added an entirely new food, chocolate milk, and restricted that. And needless to say, the Chocolate Manufacturers Association was not amused. They sued and they won because they had not been given a chance to comment on whether chocolate milk was or was not a bad thing to have in school meals. So the agency has to tell you what it's going to do and tell you why it's going to do it so you can explain if you think that they're wrong-headed. So the proposed rules carve the outer bounds of what a legal final rule can do. So notice a significant constraining factor. Second is they have to give you the opportunity to comment. This really is a distinct idea from notice, and we should think about it differently. They have to give you a meaningful chance to comment. And saying we're going to do something terrible is not giving you a meaningful chance to comment because you don't know why they're going to do it. So they have to say why they're doing it If they're relying on data or impact estimates, they have to disclose that. They have to say how it's going to affect other programs or features of programs, so that you can say, this is a bad idea, or you're misunderstanding the interaction with this other program, or whatever it might be. But anything that they don't disclose, not just in terms of what they're going to do, but why they're going to do it in the notice of proposed rulemaking, gives you a strong argument that you were not given a realistic opportunity to comment. A comment has to be something that could affect what the agency does. And if you don't know why the agency is doing things, then how could you possibly form such a comment? And then finally, they have to consider, in writing the final rule, the comments that you submitted. They have to explain that in the preamble to the final rule. And this is pivotal, and this is the one thing that I think they do worst, and this is the one thing that they're going to get even more bad at with their shrunken staff, because there can be a lot of ideas and comments. And to be perfectly honest, in Trump 1.0, I think this is an area where we didn't do as good a job as we could have. We had one set of people working on comments, another set of people litigating, and they were mostly different people. And we didn't have the commenters preparing lists of all the points that they'd made and giving them to the litigators, so the litigators could see which of these comments were responded to in the preamble to the final rule. I think there are a lot of final rules where they just ignored huge swaths of comments, which would give us a great procedural argument under Section 553C for just dumping that rule as non-responsive. And note, the lawyers and the bureaucrats cannot supplement the explanations in the preamble to the final rule. SEC versus Cheney says no post hoc rationalizations, and the Supreme Court actually in Trump 1.0 said the very same thing when rejecting their policies about having a citizenship question on the census and about ending DACA. So if they don't put it all in the preamble to the final rule, that rulemaking is invalid. And of course, if they're ignoring your comments, they're actually messing up twice. They're messing up procedurally by not complying with Section 553C, but they're also messing up substantively because it's arbitrary and capricious to disregard arguments that have been made about why your policy might not be good. Here again, there is limited emergency authority to make rules effective in less than 30 days. I don't know that that'll be a big priority for these people, but you really can never tell. These people have their own way with things. But if you look here, a substantive rule that grants an exception or relieves a restriction, that's not usually the stuff that we're upset about. Interpretive rules and statements of policy, if they follow the principles that those can't limit third outsiders' rights and can't constrain discretion, we're not going to care about that. And the only remaining thing then would be for agency good cause found. And again, there is some decent law saying impatience is not the same thing as good cause.
Professor, super. Can I ask one of the questions in the Q&A, which is HUD just put out a proposed rule where the effective date is 30 days before the end of the 60-day comment period. This does not seem okay. Do you have a thought on
No, that is not okay. They could, in theory, I mean, if I was going to defend what they're doing, I would say that they are invoking the first good cause exception I mentioned several slides ago for dispensing with public comment because of the urgency of the matter, and they're doing the public comment for subsequent actions. That used to be called interim final rule. I don't know whether HUD is using that language or not. But again, the fact that they see that they think that things is being very, very urgent because they feel very, very strongly about their policies has not been found by the court to be good cause, because every new administration feels strongly about its policies and is horrified by its predecessors' policies. And that is something that Democratic, Republican administrations alike have lost terribly. So if you look at the year after presidential election, in the FSUP, or maybe the year after that in the Federal Reporter, you will find slew of cases saying, I know you're impatient, but you still have to do notice and comment. So I don't think HUD would be able to do that very effectively. There's also, I'm not really going to talk about it much here, but there's a lot of excellent law against retroactive implementation of regulations, even where Congress told you to. I don't think there's any indication. I'm only dimly aware of the HUD regs involved, but I don't believe that there's any even half decent argument that impatience is congressionally mandated, that impatience is ideologically mandated, which is a whole different story. So there are a few other laws. They're not wildly helpful, but they have their moments, and so I want to talk about them quickly in passing. One is the Freedom of Information Act, and that's not the part of the Freedom of Information Act that most people think about, where you send in a request and they send back the documents you asked for, probably to your grandchildren. But this is a part that applies without requests, and that's paragraph 1. The send in a request and not get the documents back part, that's paragraph 3, but this is paragraph 1. And they have to put in the Federal Register guidance for the public about a number of things, including the nature and requirements of their formal and informal procedures and principles of general applicability that are put out by them that affect a significant number of people. So a lot of what they've been doing in the last 2 months has been extremely covert. You have no idea what they're up to. They're just all of a sudden, boom, someone's grant is ended, or someone's check doesn't come through. And Section 552A1 requires that these policies of general applicability be published in the Federal Register. In our day, that probably means it should be on the agency's website, but the statute also says put it in the Federal Register. Not a lot of agencies comply with this, so this is a lawsuit waiting to happen for just about anything where they do something weird that they don't have published policy on, and they do a lot of weird stuff. There's also paragraph 2, which requires the agency to have on its website, not necessarily in the Federal Register, a listing of its policies, manuals, and instructions for staff that affect the public. I specialize more than anything else in SNAP, and there are several huge manuals for states, one involving quality control and other involving some other stuff that you can find on USDA's website. And it's got all sorts of stuff that affects our clients in it. Some in positive ways, some in really bad ways. And this all by law had to be on their website. I think USDA has a history of pretty good compliance with this. I don't think some of the HHS agencies comply with this very well at all. But if it's not on their website and it's being used against our clients, then you've got a claim waiting for your filing under Freedom of Information Act 552A2. They're also where they use advisory committees or where they consult with their friends. there can be claims under the Federal Advisory Committee Act. I've long felt that many of the agencies running public benefit programs are violating FACA because of their close relationship with the American Public Human Services Association, the American Association of SNAP Directors or the Medicaid Directors or whatever it is. They're effectively talking with them in private meetings about the policies that the agency is going to be doing. And those are advisory committees as defined by the Act, even if they're not formally constituted. And advisory committees have to meet in public with publicly advertised meetings and with the documents that they're using, and their agendas open to the public as well. So where there are some new bad policies and you think they got some help from their friends, and you know, the states or the local agencies administering things can be their friends. The Heritage Foundation may be their friends. If they're meeting with the Heritage Foundation and the Cato Institute and all those people, that's an advisory committee, likely. The courts have been very, very strict on what is an advisory committee, and they will need to make that stuff public, or else the policies adopted there are improper. And finally, there is a provision that I don't think many people in our community have used, and probably isn't useful all that much of the time, but can be helpful here and there, which is that you have the right to petition for the issuance of amendment or repeal of a rule. The main thing that this will do is in theory, make them declare their reasons, and then you can attack those for being arbitrary and capricious or an abuse of discretion. The administration used to take the view, well, we didn't do this because we didn't feel like it, and it's our choice. And in Massachusetts versus EPA, a challenge to the Bush administration's refusal to consider carbon dioxide a pollutant because of climate change, the Supreme Court held that they actually do have to look at these petitions and they have to have a reason for not doing them. Now, I suppose we can't issue the rule you want because we fired all the staff that would write it, is a reason of sorts. But there may be situations where they have a rule that looks pretty clearly contrary to law, or where its negative policy implications are very, very clear, that it could actually be useful sending in a petition for rulemaking, asking them to change it, say why it's illegal or why it's disastrous, and having a claim under 553E when they predictably ignore your letter. So I now want to move on to substantive challenges to agencies' policies. As many of you know, this has changed some within the last year, but I think in some ways, those changes are very timely for what's happening right now. Agencies have four main policymaking functions. They determine law, they find facts, they apply the law they determined to the facts they found, and they exercise discretion. Each of these is subject to judicial review. I think you know what these things are. And there are distinct functions. Now, fact-finding constrains discretion. The substantive law constrains discretion. There are outside limits there, but these are four distinct functions. Prior to last spring, there was enormous deference under all four of them. Fact-finding, law interpretation, application of law to fact, and discretion. Today, there's still a great deal of deference under three of the four, but under Loper Bright Enterprises versus Raimondo, there's no longer any deference on interpretations of law. And the kinds of interpretations of law these people are coming up with, I don't know they could get very far with deference, but they're in grave difficulty without deference, and they will not get that deference now. So that means that previously they got protection on all four of these. They still get significant deference on three of them, but not on law questions. Someday this administration will make unfounded and horrible findings of fact and applications of law to fact. But at the moment, a lot of what they're doing is illegal, and they just lost their deference. Um, some examples of what some of these things are. Lots of things that agencies do are applications of law to fact, like determining what is a reasonable disability accommodation, obviously fact finding about whether a rule would disproportionately harm members of a protected class, and there's a lot of discretion about enforcement, which they are taking aggressive advantage of. But there's still a lot of law being found here, and not directly what people on this call work on, but I can't resist. Over the weekend, they got this brilliant idea that the Alien Enemies Act allowed them to arrest and deport several hundred people without any due process whatsoever. And they based that on a finding that we are being invaded by the Venezuelan government. The law requires an invasion by a foreign government, and that's just not true. Those, you can like or dislike the Venezuelan government, but they have definitely not sent any landing craft to Florida with Marines and tanks. That has not happened. So their options then are going to be interpreting laws or exercising discretion. If interpretation of law is saying the law requires something or prohibits something, and they were saying over the weekend that it requires them to round up the Venezuelans and deport them without due process. That was an interpretation of law. There also are exercise discretion, and this isn't required or prohibit stuff. This is where someone is saying it's beneficial to do X or not beneficial to do Y. And there's often some ability of the administration to choose whether they act as an interpretation of law or an exercise in discretion, but some of their actions clearly go in one pile or the other. After Chevron, some courts may invoke Skidmore versus Swift. This is not a form of deference. People call it, Skidmore deference. Well, there's no deference here because it gives the weight to what the agency said, depending on the thoroughness of its consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all factors which give it power to persuade. When my cat says it's time for dinner, I defer to her to the extent of the validity of her reasoning and all factors giving it power to persuade. Anybody is persuaded to the extent something has the power to persuade. This is completely circular. I suppose in litigating a case one might want to cite Skidmore, but it provides nothing for the agency. It's sort of a laundry list of things that you can point to as deficiencies in what the agency has done. Just to be clear, statutory interpretation is not fact dependent. Just before Loper Bright came out, the Supreme Court, through Justice Gorsuch, wrote a terrible environmental case in which he couldn't tell the difference between nitrogen oxide and nitrous oxides, which suggests that he really shouldn't be teaching chemistry. Fortunately, he found another job. But that's not a question of statutory interpretation. That's exercising discretion in applying a statute, and one hopes that people exercising the discretion know nitrous oxide from nitrogen oxides. A lot of why they got rid of Chevron, frankly, is because they don't like legislative history, and a clear majority of the court has said that they think legislative history is inappropriate. They don't always follow their own edict, and many agencies consider legislative history, so the court shut down deference to agencies so it wouldn't come in through the back door. I think we should make our arguments as if it's all based on the text and structure of the statute, not legislative history. We can have a little section or some footnotes at the end saying, and by the way, the legislative history says we're not wrong about this. But I think the elimination of Chevron is related to the hostility to legislative history, so we should be careful in how we invoke it. Okay, so let's say they're not interpreting a law, they're exercising discretion. Well, under Section 706(2)A of the APA, that can be set aside if it's arbitrary and capricious, or an abuse of discretion, or otherwise not in accordance with law. Those are administrative law cuss words. If you tell me I've been arbitrary and capricious, I'm going to ask if we can take this outside. But it actually, in the case law, has been spelled out quite clearly what that stuff means. It all depends very much on the record. If the agency under Secretary Kennedy's guidance doesn't go through rulemaking, then there really won't be a record, and any information that might be available to the agency that they could have collected arguably can be seen to be as a record because they didn't use any procedure that could further narrow the record. In general, it's actually very mechanical. It's not like the cuss words that it seems to be. It's checking certain boxes, failing to respond to concerns and information public comment, failing to respond to the reasons the agency acted previously, failing to weigh considerations the statute requires, relying on policy considerations the statute does not allow, failing to explain all facets of the action, and Trump 1.0 added to that list, which is lying. Don't lie if you don't want to be arbitrary and capricious, a lesson that some administrations have little trouble learning. Ignoring relevant considerations raised in public comments. This is, again, more or less coterminous with a violation of Section 553's ban on final rules that are not do not reflect responses to the comments. Basically, every comment there is needs to get a response. And if they don't give you a response for every distinct comment, then the comments get to eat their regulatory cheese. The courts are not generally going to weigh the merits of their responses. They're just going to see, is there a cat for every rat? And our job is to identify rats that had no cats. Those will then invalidate their regulation. If we send in a gazillion copies of the same comment, a single response will suffice. So we really want different comments, even if they aren't all that different, because each different comment will require a different response. The more different rats we send them in the comment period, the greater the likelihood they won't run out of cats, particularly since they laid the cats off. The courts have said, and Motor Vehicles Manufacturers Association is still the leading case on this, that when they change policy without explanation, in other words, they disregard the reasons that caused the policy to be made in the first place, that's arbitrary and capricious. And Justice Scalia reaffirmed that in FCC versus Fox television stations, saying that if they are making factual findings that contradict those that underlay the prior policy, or they're undermining serious reliance interests, that they have to explain why they think that the reliance interests aren't important or the prior fact findings were wrong. Again, we should collect all the rationales and all the data that supported the prior policy that we like, and if they don't have a response for each of them, they're arbitrary and capricious and abusing their discretion, and our prior policy rabbits will eat their carrots in their garden. This, not considering statutory mandated factors, the leading case on this is still half a century later, Citizens Preserve Overton Park versus Volpe. There was a conservation statute saying you should try very hard not to put highways in the park. They wanted to put a highway in the park, and they didn't consider all the things that the statutory suggested, such as the importance of preserving parks. So it was invalid. If there are 5 factors that you can discern in the statute that they're supposed to consider. They have to consider all 5. If they miss one, they're arbitrary and capricious. In addition, they can't say, oh, we did think about that. We just put it in the documents, because again, post hoc rationalizations are not allowed. They also, from Overton Park, cannot consider statutorily prohibited factors. There, they said, well, it'll be really pricey to not put the highway in the park. And the court said Congress knew that destroying parks was cheaper, and it rejected cost as a factor. And so this is an improper consideration. If the statute says consider 5 factors, don't care about cost or views of local government, and they consider costs and views of local government, they are arbitrary and capricious and abusing their discretion. And if they provide a rationale that supports part of their policy, but not the rest of it, that is also arbitrary and capricious and abuse of discretion. The DACA case in Trump 1.0 was great on that. The court said, well, yeah, they gave us a reason for getting rid of some of it, but they didn't explain why they're getting rid of the rest of it, and failure to support all facets of the policy is arbitrary and capricious and an abuse of discretion. There also are cases about covert influences on policymaking, meaning that the record is not the real record, that the policy was driven by secretive conversations that are not disclosed. HBO versus FCC is the leading case on that. And again, the lying problem from the census question case, where Chief Justice Roberts says that their rationale, their sole stated reason, seem to have been contrived. Lying is how I would say it, but he's got better manners than I do. Accepting contrived reasons would defeat the purpose of administrative law, says Chief Justice Roberts. Amen to that. And so when they are saying do it, just do it, and one can get witnesses or memos or whatever that show that they were not considering legality when they did it, then the courts are not bound to take seriously things in the Federal Register saying that they carefully considered this, that, or the other thing.
Professor Super, we have
time. So rather than going through my slides on access to judicial review, maybe questions?
We have about 1 minute for questions, and maybe we can either cover access to judicial review in our April 2nd training, or people can review that in the slides that I'm going to send out after today's session. But any questions that people have, you can come off mute and ask. All right, we don't have any questions in the Q&A function, so I want to thank you so much for this incredible amount of information that you've been able to share with us today. I think we're all looking forward to the April 2nd session. Do you have any thoughts, parting thoughts before we close the session for today?
Not much, other than the fact that in my experience, we care more than they do, which means we have better attention to detail than they do. And they're doing this out of spite. We're doing it out of love. I think we will do better work than they do. And ad law is very rewarding of people who do better work and harder work and more careful work.
Love that. We're doing this out of love, not out of spite. That's a great way to end on this. And we will see you back here in 2 weeks. Thank you so much, Professor Super, and thank you everyone for joining.
Thank you very much.